Stop. Before listening to this podcast, please take the following quiz. The First Amendment to the Constitution of the United States provides, in part, quote, Congress shall make no law abridging the freedom of speech or of the press, end quote. On the basis of your personal understanding of this sentence's meaning, not your knowledge of constitutional law, please indicate whether you believe the following sentences to be true or false.
Got your pen, got your paper? Okay, here we go. Number 1. In time of war, a federal statute may be passed prohibiting citizens from revealing military secrets to the enemy. True or false? Okay. Next one. 2. The president may issue an executive order prohibiting public criticism of his administration. True or false? All right. Number 3. Congress may pass a law prohibiting museums from exhibiting photographs and paintings depicting homosexual activity. True or false? Got it? Okay. Number 4. A federal statute may be passed prohibiting a citizen from falsely shouting fire in a crowded theater. True or false? All right, number 5. Congress may pass a law prohibiting dancing to rock and roll music. True or false? Okay, number 6. The Internal Revenue Service may issue a regulation prohibiting the publication of a book explaining how to cheat on your taxes and get away with it. True or false? All right, number 7. Congress may pass a statute prohibiting flag burning. True or false? All right.
Thank you.
Got all your answers marked down. We'll come back to solving this little riddle in a second. That's the opening to today's article.
What is the name of this article that we're reading today?
It's called The Myth of the Rule of Law from John Hasnas published 1995.
So, of all the essays that we've read, and, looking back on our previous episode, Max Stirner, this is pretty recent. We don't often read stuff that's this new, actually.
Yeah.
And yeah, so what is this essay about? It's about this idea of the rule of law. Is there such thing as an objective law? And if there isn't, what solution can we find in place of that? And how can we live in a fairer or more just society?
Yeah, so this guy, John Hasnas, is a Georgetown University law professor. He knows his shit, but so rarely is he one of us, so to speak. He has seen through all the shit, and he's here to give the libertarian or anarchist, or however you want, rebuttal to the minarchist argument that we can have kind of a minimal government that only services, the rule of law and policing and all that. So this guy's here to explain to us why there is no such thing as objective law, and why, in fact, to get to a free society, we must abolish the government monopoly on law. Damn, sounds pretty challenging. Sounds pretty, almost no one would probably agree with this on the outset. But
yep,
this guy has pretty compelling points.
Yeah, we're going to need some heavy logic to fight our way through this. And I think John Hasnas, he's got the I'm trying to think of the expression. There's an expression in the UK, you've got the stones. It's like you've got the balls for it.
Yeah.
But all I could think of is he's got the melons.
he's got the Hasnases.
He's got the melons for it.
Okay, should we...
I was going to say we begin the essay with a reference to 1984 and the concept of doublethink. obviously George Orwell's famous science fiction novel, and this technique of doublethink used by the totalitarian state, which basically engineers a scenario where people hold two simultaneous opinions which cancel themselves out without being aware of the fact that they're contradictory. So he argues that this is actually a real thing and not just like a kind of a nice literary device. And he uses the legal system as an example, saying, that people are obviously aware that the law itself is an inherently political thing. All we have to do is look at, rulings in Congress from the last couple of years, like Roe v. Wade, for example, being overturned, to know that, the weight of Congress and the people who are holding positions have a huge influence on law that ends up informing further, law throughout the whole country, right? However, he argues that we also have this idea that the law is that there is this concept of like objectivity in law, and that law can be impartial and can be kind of applied impartially, and even like the system itself makes sense. He argues that it doesn't.
Yeah, and with that little double speak intro in mind of people holding contradictory beliefs, maybe it's useful to just resolve the little quiz from the beginning now, to see how that applies in practice. So I hope you all, dear listeners, have marked down true or false to the 7 points we read. If not,
definitely go back.
Yeah, now is your chance to go back, rewind, and actually do the quiz. There are no wrong answers. And yeah. So let me again restate the First Amendment, which is technically a slightly abridged version. In the full First Amendment, it says Congress shall make no law abridging the freedom of speech and assembly and blah blah. So there's a bunch of more stuff in here, but he's shortened it down to these specific aspect of Congress shall make no law abridging the freedom of speech or of the press. And so it's slightly abridged, but the other parts, they're not, he hasn't falsified the amendment, right? He's just cut out some extra stuff. Okay, so no law abridging the freedom of speech or of the press. Okay, so for point 1, which was, in time of war, a federal statute may be passed prohibiting citizens from revealing military secrets to the enemy. I answered true. Nick, do you remember your answer?
I answered true.
Right. I think that's the common answer. And, Professor Hasnas tells us if your response to question 1 was true, you chose to interpret the word no to mean some, which, as we look back on it, it kind of does say pretty clear Congress may pass no law, but if we make an exception, then okay, it's already not no law anymore. There we go. Point 2. The president may issue an executive order prohibiting public criticism of his administration. I said false. This is pretty much egregious censorship, no?
I agreed. This is false.
Although John Adams did technically do this. So Hasnas tells us, if your response to question 2 was false, you chose to interpret the word Congress to refer to the president, and the word law to refer to an executive order. Ah, right, okay. I was like, fuck, I didn't think about this properly. So Congress obviously is not the president. An executive order is part of the executive, not the lawmaking organ. But if say Donald Trump, for example, would make a law banning criticism against him, we all know that the media reaction, and rightfully so, would be, but what about the First Amendment? So we all kind of understand the amendment to also apply to the government in general, even though it technically only mentions Congress. Point number 3. Congress may pass a law prohibiting museums from exhibiting photographs and paintings depicting homosexual activity. I said false. Congress may not do this.
I also said false.
Okay. So if your response was false, you chose to interpret the word speech and press to refer to the exhibition of photographs and paintings. Yes. I think this is one of those age-old free speech kind of issues, like what actually consists as speech. And if we go into the more like critical theory kind of realm, which is also mentioned later in the essay, we actually, I think we've all heard the slogan "speech is violence" recently.
Mm-hmm.
So we can quite stretch this. Okay. So number 4, a federal statute may be passed prohibiting a citizen from falsely shouting fire in a crowded theater. This is kind of the classic
free speech crux debate.
Yeah.
Mary Roth false.
Yeah, I said true actually. So Mary Rothbard has a very interesting point of this, but just intuitively I said true. It says if your response to question 4 was true, you have underscored your belief that the word no really means some.
Yes. Yeah.
I was like, I'm a dunce.
To be honest, this was my thought with 1 as well. But yeah. Number 5. Congress may pass a law prohibiting dancing to rock and roll music.
I said false.
I also said false. And a similar kind of point was raised to point 4, which is like, if you answer this as false, then you recognize... 3, that is, about the museums exhibiting photos and depicting homosexual activity. You're understanding speech and the press as rock and roll music, which is kind of further down that line of like abstract. What is speech? What is the press?
Like, what if the music has no lyrics? Does that change anything? I don't know.
Yeah, and even if it does, is that speech?
Okay, number 6. The Internal Revenue Service, the IRS, may issue a regulation prohibiting the publication of a book explaining how to cheat on your taxes and get away with it. I said true, just because I don't know if there actually is such a book out. I feel like there probably would be if it wasn't illegal. So.
Yeah, I mean, I think it's. I answered false, not because I don't think that there is such a book that could exist, and not because I don't. I answered false not because I thought that there existed a ban, but more because might is right. As Stirner would say.
Yeah, okay. So if your response to number 6 was false, you chose to interpret the word Congress to refer to the IRS and the word law to refer to an IRS regulation. And the last one. Number 7, Congress may pass a statute prohibiting flag burning. I said false.
I answered false here.
Yeah.
Yep.
Just because I feel like we always see NFL players doing this. So I was like, if this was illegal, that would probably, I don't know. So if your response to question 7 was false, you chose to interpret the word speech and press to refer to the act of burning a flag. Right. So and he says, unless your responses were 1 false, 2 true, 3 true, 4 false, 5 true, 6 true, and 7 true, you chose to interpret at least one of the words Congress, no, law, speech, and press in what can only be described as something other than its ordinary sense. Why did you do this? Were your responses based on the plain meaning of the words or on certain normative beliefs you hold about the extent to which the federal government should be allowed to interfere with citizens' expressive activities? Yeah. I think...
So I think with this kind of in the air now, this little quiz, how does this tie to the main position that this book holds? I think as you kind of suggested earlier, there are no wrong answers, but there are also no correct answers. And the whole kind of point of this book, this essay, is trying to illustrate that when we approach questions like this, each of us bring our own assumptions about what is right, and kind of imbue our answers to this with those assumptions, and that this is kind of a thought experiment that applies to the whole world of law and the practice of law. Would you agree with that?
Yeah. So let's say, for example, you are on your libertarian journey and you have read, say, the Road to Serfdom. We have covered it on the podcast. I think it's episode 16 or something. So Friedrich Hayek in The Road to Serfdom says, what's really troubling is when government acts arbitrarily outside the rule of law. A big part of that book is saying that we really need the rule of law to very definitively define what steps government is actually allowed to take, in what scope, when, and what kind of retaliation the citizenry can do against that, and so on. So he says we really need to hammer down on this idea of the rule of law, on objective law that defines what exactly happens in what case. Otherwise, we kind of get arbitrary decisions by demagogues, and that's dangerous. Now we read this guy, and he's like, well, sorry guys, but there is no rule of law, and there is no objective law. And so, yeah, I guess we will just lay out this case step by step as he does in this essay. And, if this guy can convince you, then yeah, I guess there is a problem with Hayek's view of how to fix authoritarianism.
Yeah, and Hayek as well, he is like one of the kind of considered a fundamental kind of foundation of minarchist philosophy. Whilst he obviously talks about the state as a tool of violence, he's also makes room for things like early conceptions of what's the word?
UBI.
UBI, yeah, and like socialized welfare and healthcare and stuff like that.
Yeah. Okay, so John Hasnas in this essay has really three kind of theses he puts out. First, there is no such thing as a government of law and not people. So we've heard this phrase, perhaps, a government of law and not people, means that the law is objective. There is a thing called the rule of law. And yeah, it's what happens in any given case is not decided by the whim of the people in those positions, but the law is so clear that we can it's kind of predetermined how a certain case would be judged. Number two,
and when you say
yeah.
When you say the people in those positions, you're talking specifically about the judges that have the authority to rule in cases, as well as anyone that has authority, whether like a police officer, for example, as well.
Mm-hmm.
Yeah. So the idea is, a good way of imagining this is like an idea that the police who hold this authority, this authority to inflict violence, to arrest people, and to make judgments on behalf of the state. There's this prevailing idea in a lot of circles that the police are able to do that, as governors of the law and not like human beings themselves.
So
carry on.
I think we've seen this on Instagram or whatever a billion times of like some guy going into some place filming to piss off the police, and then the police is like, you can't film here, and then he's like, yeah, I can film here because this is a whatever place. And so if we were truly in a society of laws and not people, then that shouldn't happen really, or that should happen like once or twice, but then it's struck down in the court of law, and everyone should pretty much know where you can film and where you can't. But the reality, of course, is that between federal law and state law and whatever rural, predilections and fucking your property and public property, and it's technically public property, but within the public property, there's like this private office or whatever, that it's actually not that clear what the law says on this issue. Okay. Number 2 of theses this guy puts out. The belief that there is so attaching to number 1, there is no such thing as a government of law and not people. He says, the belief that there is serves to maintain public support for society's power structure. And number 3, the establishment of a truly free society requires the abandonment of the myth of the rule of law. Okay, so number 1, there is no rule of law. Number 2, the myth of the rule of law supports society's power structure or government. Number 3, in order to become a free society, we need to abandon the myth of the rule of law. Got it.
Great. Yeah, and if you have any, Phil, you've summarized it beautifully, and I will also just add on that the essay itself is very well structured in order to communicate those arguments and to address them in very nice order as well.
Yeah, and it's also very easy to read and very humorous. So yeah, quite enjoyable.
Yeah.
A slight elaboration on this point number 2. He says, for if citizens really believe that they are being governed by fair and impartial rules, and that the only alternative is subjection to personal rule, they will be much more likely to support the state as it progressively curtails their freedoms, right? So if you think there is such a thing as objective law, and you're not just at the mercy of the judge or the governor or the congressman or whatever, then yeah, you're probably more likely to actually concede such things as taxation or you not being able to speak freely in a certain environment. Like let's say in the UK, they came up with this wonderful thing called non-crime hate incidents, which means that you can get sued and punished for something that's not a crime, and it's essentially just like insulting someone or saying like making a joke. So what makes people accept this kind of thing, according to John Hasnas, is that they think because there is such a thing as objective law, as long as they simply stay within the bounds of that, they're going to be fine and they're going to be judged fairly. And if you get punished, then that's because you transgressed the law, and yeah, you should have known better. Okay. Maybe let me just throw another quote into this. Oh, God damn it. There it is. He says, in the legal world, however, this assumption does not hold. The assumption being that there is kind of a logical way of law, a kind of objective reasoning inside the law. This is because, unlike the laws of nature, political laws are not consistent. The law human beings create to regulate their conduct is made up of incompatible, contradictory rules and principles. And, as anyone who has studied a little logic can demonstrate, any conclusion can be validly derived from a set of contradictory premises. This means that a logically sound argument can be found for any legal conclusion.
And so he makes the distinction here between, traditional reasoning, where we, use hypotheses and question things. If I see something on someone's feet, I'm like, what is that on their feet? I can ask questions about what it is and come to the conclusion that they're wearing shoes. And go, okay, they've got something that's covering their feet. It's got these like string things. Maybe those are laces. It seems to have some kind of rubber bottom. I think these are probably shoes. But he describes kind of when it comes to legal reasoning, the fact that you don't use facts to support your argument, but rather you use laws and you use legal precedent, as a means of arriving at the conclusion that, for example, this person involved in a scam, for example, this person who was scammed, for example, was wrongfully done by and is therefore worthy of recompensation by the person who is determined to be the scammer. He does this through it's really, so I think we really should bring attention to the way that he writes about this and the way that he develops this argument, because it's he does it through the discussion of these hypothetical legal situations, and the different choices that two of the lawyers make. We have Arnie and Anne. And
Arnie is like a staunch conservative. He believes in merit and fairness and, kind of, personal responsibility. You get what you have coming. And Anne is a more...
described as a bleeding heart liberal. Caring, empathetic. This isn't like super essential because it gets a bit less clear what their stances would be as we go further on, but the point is that they're kind of ideologically divided in certain ways. So he sets up the first example that he sets up is this essentially a woman living in a rural setting who only has access to a physician, like a local doctor, so who is like not as readily available as you would be in like an urban area. This woman falls ill, and when she calls the doctor doesn't respond because the doctor's on their day off. And the woman ends up dying because she couldn't get care for that day. So her estate then sues the doctor for not coming to her aid. The question is the doctor liable? And he then describes the process that Arnie and Anne go through. I wish he called them Arnie and Barney or something and not double A, like A and A, but whatever. So Arnie, he goes through his research, he discovers a case which establishes a rule that in the absence of an explicit contract, I won't actually go into the details because it's not super important. The point is that he goes through his research and he discovers an existing case which establishes a rule, and he uses that rule in order to justify, in order to defend the doctor and saying that they're not legally liable. And then Anne takes exactly the same process. She does her research on previous cases and discovers another case. And this case establishes a different rule. And this different rule serves the person's estate, the person who died. And so when they meet, they argue. Arnie puts forth his case which defends the doctor. And Anne listens to this and goes, this is a typical privileged white male conservative with no sense of passion, to quote the text, who missed the point of the hypothetical. She then ends up giving her argument, and Arnie reads that as this, misguided, bleeding heart liberal whose emotionalism has caused her to miss the point of the hypothetical. And the essential kind of takeaway here is that neither of them are right, but rather it's an example to kind of illustrate that the flexibility of the legal system in providing answers as to who would be liable in different situations.
Yeah, I think let's go through the civil rights one, the affirmative action one. I think it'll be useful to illustrate the underlying principle as well. So yeah, in another example, again, Arnie and Anne are present here. We are discussing Title 7 of the Civil Rights Act of 1964. And you can look this up if you want, paragraph 2000E-2A1, which says that it is unlawful to fail, and this is a quote, to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Okay, I think this is kind of what the Civil Rights Act is very much known for, right? That you can't get fired because you're black, absolutely. Basically. And yeah, on a little side note, very interestingly, because I thought about this in the German Constitution recently. What of course you do with such legislation is that you write it into law that there is such a thing as race, right? So, which it can also be quite problematic, like, because obviously in the modern society people are of mixed origins, and realistically you're like 23% Nigerian and 28% Irish and whatever. But yeah, once you've written into law that there is such a thing as race, we actually get into kind of shitty territory. But
yeah.
Anyway, so having this in mind, that you can't discriminate against someone based on their race. Arnie and Anne both dig up two different legal precedents. All right, should we need to state the case first, right? So that it's about whether or not affirmative action is like if an employer, if a company wants to use an affirmative action program to preferentially hire, let's say, minority individuals, whether that is okay or not okay with the Civil Rights Act. And so Arnie digs up the precedent, quote, when the words are plain, courts may not enter speculative fields in search of a different meaning, and the language must be regarded as the final expression of legislative intent, and not added to or subtracted from on the basis of any extraneous source. Basically saying, Civil Rights Act says pretty clearly you can't discriminate based on skin or race or whatever. So yeah, pretty clear language. So Arnie says, okay, therefore, affirmative action is not okay with the Civil Rights Act because, of course, it says right there you can't preferentially hire someone based on race. So if you do that, even if you hire minorities preferentially, you're still discriminating against other people's race. Now Anne digs up a different legal precedent that says, quote, it is a familiar rule that a thing may be within the letter of a statute and yet not within the statute because not within its spirit, nor within the intention of its makers, and that an interpretation which would bring about an end at variance with the purpose of the statute must be rejected. So that is to say, the purpose of Title 7 of the Civil Rights Act is to, quote, relieve, and I'm quoting here, okay, is, quote, to relieve the plight of the Negro in our economy and, quote, open employment opportunities for Negroes in occupations which have been traditionally closed to them, in the language of the Civil Rights Act. So very specifically, the Civil Rights Act is trying to protect racial minorities. So Annie says, of course, a program to favor racial minorities wouldn't be against the Civil Rights Act, it would be within the spirit of the act. And in fact, to make this a kind of conversation, it would be within the intention of why it was made. And to make this a conversation about discriminating against about white people would be to miss the point of the Civil Rights Act.
Yes.
So where does that leave us, Nick?
We're at a point. We're in a situation where neither of them are right and neither of them are wrong, and we're kind of in a situation where, well, we think about like the role of a lawyer, you know, to deliver justice or to fight for justice. But we also know that justice is just the justice that is delivered, whether it goes in one way or the other, is delivered on the back of this super kind of atomized, like, tiny speck of detail, to the extent, you know, where you can imagine lawyers as less of these kind of fighters for justice and more as kind of like very good researchers that are scouring these sacred texts in order to find like a scrap of information that can be used in an argument towards a certain thing.
Exactly. And that certain goal, that certain premise that they go into the whole thing with kind of determines their conclusions, right? So both think that they've done their research.
Exactly, yeah.
They found a legal precedent that completely, or a statute, whatever you want to call it, that completely supports their view. And so therefore they think, according to the kind of regular, you know, real world logic, if my thing is true, everything else must be false. And so, yeah, they bring that to the table. But of course, as Nick said earlier, in the legal world, statute is not natural law. It is made up by people, and it's just subjective judgments of people. So it very frequently happens, of course, that you can have completely contradicting statute, and whatever you pick up depends simply on what you're looking for. And so both think they're right, both think they found the true meaning of the law, and that the other one is just perverting the law politically.
I think as well, it's a really it's an important point to make here, that neither of them, it's not actually about what's right and wrong. So, you know, whoever's like, to those listening, the kind of most important part of this text, I think, is that it's really not a kind of a judgment on, you know, whether you think whatever outcome to this case is right is right or not. It's more trying to show this contradiction. And I think as well, another thing is to, you know, kind of imagine these statutes or these precedents in situations outside of this case, in another situation that might matter to you in a different way. And, you know, say you might be you might agree that you know, the objective of the Civil Rights Act is to relieve the situation of minorities, but you might also lend credence to Arnie's opinion if it were a completely different scenario. And so they're kind of like, these laws, these statutes in themselves only serve the purpose as far as the case itself goes. And they're not, you can't consider them as like unifying universal laws that apply to everything, because they just don't.
Yeah, I think the crucial point here is, as we kind of talked about a little bit already, is, that there really is, you can't approach law like you would any natural, or even like anything in real life, right? If, like you might, for example, find a statute that says something like anything with 4 legs, in a living room, not otherwise specified as a table, is a chair. And then you might find another statute that says like, any 4-legged thing in a living room, that is of a certain size above this, square meterage, is a table. And so you can have 2 people arguing about whether this is definitionally a chair or a table, when in reality it could actually be a donkey. It just isn't a living room.
Exactly. Yeah. The question of what is a chair is a bit of a meme at this point, and it's very relevant, I think, to this argument. That's a really good point. I hadn't thought of that.
Yeah, because it's really quite impossible to really define any objective, real thing in law, right? And if currently doing all the nautical science stuff, I've had to take a class on, of course, maritime law. And, what we kind of discussed in lesson 1 is that there is no such thing as a ship legally. Like, there is actually no legal definition of what a ship is, which obviously is kind of a problem.
Welcome to maritime law, where we still haven't figured out what a ship is.
Yeah. Because considering statute and everything, you simply can't define, no matter how you define it, you will always leave various back doors that you could fuck you later. So you'd rather not define it.
So I'm glad that you mentioned this kind of like idea, when you kind of try and nail down a definition, there will always be back doors. It brings to mind an idea that I originally first heard connected to AI, but generally works when talking about any kind of task, goal-seeking behavior. The basic idea is that the way that you define a goal for yourself is really important, because there are all manner of ways which you can strive to achieve that goal. And they might not always actually line up with things that you kind of assume to be common sense. So you can give the example of losing weight. Say I decide that I wanted to lose 3 kilos in a couple months, 3 kilos in 3 months, let's say. If I said that to you in a normal conversation, you'd probably think that I meant, okay, this guy's going to start exercising, he's going to start dieting a bit.
Ozempic.
Thanks for rushing to the conclusion.
I know you, Nick.
The reality is that there are all manner of ways which you could achieve this goal. And we'll also kind of maybe surprise ourselves in the way that we strive towards that. So, yeah, it could be, for example, you take Ozempic, but you could also achieve that goal by cutting your own arm off, right?
Right.
And this might seem like a ridiculous idea, but actually, in the case of like law, anything goes, right? When it comes to trying to put forward a convincing argument in defense of something. So, yeah, I might think that it's common sense that losing weight means dieting and exercising, but in this kind of creative realm of law where you're trying to find these neat solutions and these details, cutting your own arm off is a perfectly viable solution.
It's like the Merchant of Venice, where the old Shakespeare thing, where the Shylock, the Jewish merchant, makes this pact with the Italian guy, I'm just gonna call him Antonio. Maybe that wasn't his name. Of like, if you lose these ships, if you lose this freight, then, you know, if you fuck up this deal, then I'm entitled to a pound of flesh from you. And they signed the deal. And then, of course, the Italian being, or I'm not going to finish that sentence, but of course he fucks up the deal. He loses the freight. And then, the Jew being portrayed as kind of an evil, tricky creature in Shakespeare, shocker, is like, where's my pound of flesh? And then when it goes to court, and they're like, yeah, but well, I mean, we agreed on a pound of flesh, but like, not really, right? Surely,
right.
You don't actually gain anything by cutting a pound of flesh out of me, do you? Like, and so, yeah, it kind of ends by just being like, oh, the Jew sucks, and, you know, he loses everything, but which is why I don't like that play. but yeah, as you said, kind of a common sense that is assumed to be there is maybe not always clear. Yeah.
So you might argue against this and say, okay, what if we had much more clearly defined laws? And of course, Hasnas has an answer to this. And I have two quotes here which are closely put together in the text, and I'll read them for you now. As long as law remains a state monopoly, as long as it is created and enforced exclusively through government bodies, it must remain indeterminate if it is to serve its purpose. Its indeterminacy gives the law its flexibility. And since, as a monopoly product, the law must apply to all members of society in a one-size-fits-all manner, flexibility is its most essential feature. The goal of the law is to provide a social environment which is both orderly and just. Unfortunately, these two purposes are always in tension. For the more definite and rigidly determined the rules of law become, the less the legal system is able to do justice to the individual. Thus, if the law were fully determinate, it would have no ability to consider the equities of the particular case. This is why, even if we could reform the law to make it wholly definite and consistent, we should not. So he kind of like really neatly articulates this dichotomy between rigidity in the law and vagueness in the law, and the usefulness that they both provide, or rather
yes.
the kind of problems that they both provide. So
we found here a really kind of an antithetical view to Hayek's, right? Hayek's told us that anything that is indefinite in the law leaves room for arbitrary political manipulation, and so the law should be as definite as possible. Whereas this guy, Hasnas, he says, no, actually, the law being indefinite and leaving some room for interpretation is necessary for it to fulfill its kind of purpose of also serving justice, right? It serves both the order of society by being definite, and it also serves justice by being indefinite and allowing for judges to judge cases on their merit. So he says, actually, law should be a good bit indefinite, if it should be at all.
Yeah.
But yeah,
if it should be at all, for sure. But then, of course, the further indefinite you get, if the power of the state remains consistent, the more power the state has to do basically its own bidding. And that's kind of, I feel, when you get into territory, like you said, about the no crime hate instances in the UK, for example, which are kind of like so far removed from like legal sense, but give the state this kind of enormous power to basically do what they want. So,
just quickly,
he
gives us an example of what could, for example, happen if we had a perfectly definitive law. I think this is worth mentioning. So I'm just going to read this bit. Let us assume, contrary to fact, that the terms fraud and physical compulsion have a plain meaning, not subject to interpretation. The question then becomes, what should be done about Agnes Shyster? Agnes was a lonely and elderly widow who fell for the blandishments and flattery of those who ran an Arthur Murray dance studio in Des Moines, Iowa. This studio used some highly innovative sales techniques to sell this 68-year-old woman 4,057 hours of dance instruction, including 3 lifetime memberships and a course in Gold Star dancing, which was, quote, the type of dancing done by Ginger Rogers and Fred Astaire, only about twice as difficult, end quote, for a total cost of $33,497 in $1960. So yeah, probably perhaps millions today.
Probably like $3.5 billion today. $350 billion.
It's basically a Ukraine 1 year war in Ukraine kind of dance lesson. So of course Agnes did voluntarily agree to purchase that number of hours. Now, in a case such as this, one might be tempted to interpret the overreaching and unfair sales practices of the studio as fraudulent and allow Agnes to recover her money. However, this is precisely the sort of solution that our reformed determinate contract law is designed to outlaw. Therefore, it would seem that since Agnes has voluntarily contracted for the dance lesson, she is liable to pay the full amount for them. Or he brings another example of like someone who inherits their grandfather's fortune, but it turns out that they actually killed their grandfather to get the fortune. So, you know, if we stay definitive to the law, it's like, yeah, technically.
Let's stick with this one example.
Okay,
I think,
right.
This gives it very, I think, quite clearly. You know, this would probably go against the Heinrich space colony anarchy, where contract is bound, contract is law. You know, at the end, there's an end of this one bit here, which basically says, yeah, this might seem harsh, but from now on, vulnerable little old ladies will be on notice to be more careful in their dealings. You know, the kind of Heinrich thing in The Moon's a Harsh Mistress is kind of Heinlein, sorry. Is that through the creation of this new society, people will die off, but there will grow kind of this new consciousness about how to live within this system. But yeah, it's very hard to kind of, in some kind of like common sense, again, and we're talking about common sense, which is difficult, but to at least recognize that, you know, a 68-year-old woman shouldn't be buying 3 life memberships of dance instructions and 4,000 hours of dance videos and all that shit, right?
Yeah, it's like,
so
I totally get the point he's making, and he's right on many levels, but I'm temperamentally much more of an Arnie than an Anne guy. So and this is the same reason why I didn't like The Merchant of Venice. Is like, well, I just felt like, oh, he's entitled to his pound of flesh. What the fuck are we talking about here? So
yeah.
You know, it's like, if at the end of the day, if I had to choose between a world where we truly had the more definitive type of law he describes here, and, you know, if you got tricked into buying like a fortune worth of dance instructions, then you just gotta pay. I'm sorry. But on the other hand, I don't know, for example, free speech actually means free speech, and, you know, Tommy Robinson wouldn't be in prison right now in the UK. I'd be happy with that world, you know.
Right. And you know, again, it's kind of we have natural sympathy, I think, towards this, you know, this kind of old woman,
insufferable hag, as I call her. So.
We wouldn't apply the same sympathy to a bank, for example, getting bailed out for making a colossal mistake.
Yeah.
You even in a situation where you could prove that, no one was really liable. I don't know. But again, I think the example is used to kind of, it's supposed to ply you emotionally. It's supposed to, this woman from this random place in Iowa, this lonely elderly woman, this poor person that doesn't stand a chance, and that got plied because of who she was. This is like this is clearly an example that's meant to appeal to your emotion. Yeah.
Yeah, and then he kind of goes through the motions of a couple different cases. I think they're all very interesting. We won't list them all here, but it's definitely worth reading. And I like this scenario he puts up where there's the three judges on the panel, and one is Annie, one is Arnie. They can't agree on anything, and the third guy is like Barney or whatever, who was only appointed because his uncle is the governor, and he doesn't know anything about law, but he just kind of judges on whim at the end of the day. And it does feel like that is kind of how decisions are actually made.
100%. So then we go into the next section where he talks about he makes quite an interesting and I think quite good argument about normative assumptions and normative beliefs, and the kind of the culture of the legal profession and judges specifically. He talks about this idea of the stability of the law. He basically says that the law appears to be one of the reasons that we consider the law objective is because there's stability in the way that the law is practiced. And of course, that he's not saying plainly, I believe that the law is stable. He's just talking about a kind of commonly held belief. And
yes.
so what
so
he
for
does
instance,
to kind of give this example, he points to the judges in the country, the kind of backgrounds they come from, the kind of educations they receive, and the kind of people that they naturally would be generally, by being the kinds of people that would be able to, go through law school, go through the admissions tests, and then achieve careers as attorneys, and also goes into talking about how their politics would tend to be a certain way, and how historically, these people would have typically been white males, and of specific religious pedigrees, mainly Christian, right? And that kind of inculcates a specific culture, which tends to give a trend in outcomes. But he argues that this is just like a stability in the application of the law, and it says nothing about the objectivity of it. It's more just kind of like a consistent bias.
Yeah, for instance, you might, having considered the previous examples, you might think, okay, sure, there are instances where the law isn't always clear, but I mean, I can see in my everyday life that the law is stable, right? If you steal something in a store, then you generally get arrested for it. That's kind of how it works. So the idea that law isn't objective, you might think isn't truly correct, because it seems that in general, the laws seem to be followed and judges come to the same conclusions. Like if you steal from the store, then you get whatever, it's a felony or whatever it is, And he says that is, as Nick said, that is not because there actually is such a thing as objective law, which is your mistake in inferring that, he says, but it's simply because the judges come from a similar cultural understanding of the law and of just regular norms, which also, of course, is reflected in society and the jury. So we all generally kind of understand that stealing is wrong. So therefore, we would convict someone of stealing from a store. And that's why there is stability in such rulings, not because the law is actually so definite that it's not possible to get to the other opposite conclusion. And of course, we've seen this in California, literally over in San Francisco and LA, where I forgot what the amount is, maybe $900 or something. But they decided that if you steal under $900, it's not a felony anymore. And so people just get away with it. And literally you see tons of videos of security guards just standing there being like, yeah, there's nothing I can do. Just take it. And so now you have all these, stock price of Target and the Walgreens just fucking plummeting. And if you go to the stores, a lot of it, like the shampoo's chained to the shelf and shit. So, so demonstrating that actually law isn't stable. It's just the norms that are shared, which gives the appearance that there is such a thing as stability in the law.
Yeah, and we end up talking about what's the term? It's like the can't believe I'm blanking on it now. The critical legal studies movement. We'll get into that in a second. But the critical legal studies movement is a movement, I think probably in like this beginning in the 70s probably, but like gaining traction in the 80s and 90s.
It's what later produced or kind of came out of the critical theory of the Frankfurt School, and we are now dealing with in terms of critical race theory and that kind of stuff. All came kind of out of the legal departments of Harvard and so on.
Yeah, and this was kind of originally based on a critique of this previous legal culture, which was which they criticized as being disproportionately unfair to minorities, specifically like African Americans, and then seeking to kind of balance that injustice. But before we get to that, because I think this is a really interesting conversation too, but I want to go in order here. There is a really important quote, two quotes here that I want to give. The first is a quote from John Wendell Holmes from 1897, and the introduction to this quote is basically saying, this kind of idea that law is not that law is indeterminate, and that law is a production of our emotions and our culture. This guy, as early as 1897, this idea was floated around, and the quote is, "The language of judicial decision is mainly the language of logic, and the logical method and form flatter that longing for certainty and for repose which is in every human mind. But certainty generally is an illusion, and repose is not the destiny of man. Behind the logical form lies a judgment as to the relative worth and importance of competing legislative grounds, often an inarticulate and unconscious judgment. It is true, and yet the very root and nerve of the whole proceeding. You can give any conclusion a logical form." And I think this kind of gets to the crux of what we have been talking about from the very, very beginning. You find some legal precedent. This forms your logic for your argument. But the thing that forms this kind of desire to find this in the first place is your kind of initial emotional and probably unconscious judgment of a situation, which is informed by a whole life of experience. And I think this is true.
Yeah, I mean,
the second quote.
This whole thing.
This is just a very.
Okay, go on.
Oh, go on.
All right. The whole thing of statute in law has always driven me crazy from the first moment I ever heard of it until now. I mean, I get kind of why it exists, but my God, this is such is this not like completely retard logic? Like by referring to statute, you're simply saying, this case should be judged this way because at some point in time, some guy judged a similar case the same way. We're not at all talking about whether, that was the right decision, whether the outcome was better that way, whether that was, fair to the different parties. We're simply saying some guy at some point said this. That's literally the fucking reasoning behind it. Like it seems so weird. Like I don't know. Like if you treated anything else in real life that way, you would sound like a moron. Like you wouldn't say,
yeah, it really,
like it's okay to kill women and children because I opened the history books and let me tell you, there is some statute for that shit. Like there's people doing that in the past and they did a lot. So it's pretty solid statute right there. So I think we should do that. Like that's just not how you logic anything.
And we can talk about like legal, like not legal, like scripture law as well. Like, the Bible doesn't, the Old Testament doesn't say anything about slavery, right? Slavery being bad. Therefore, is it okay? You don't see anyone making that legal argument.
Yeah,
that argument, that religious law argument.
And also, I get that it's kind of, it's the point of common law. It's like this evolvement of a certain, cases and, this type of case should be judged this way. And it kind of evolves in a certain branch to make sure that shit doesn't go crazy outside the margins. But I don't know, like we often with statute, we reach so far back, like 100 years or some shit. And it's like the people we are referring to might have been lawyers, but my God, they were probably people who couldn't comprehend the idea that black and white people use the same bathroom, and I probably wouldn't pass the bar today at all. But somehow their statute is like ground shaking for this case. It drives me insane.
Yeah. So, I think, there's a great quote here, a short one, which says, "The rule of law is a myth, and like all myths, it is designed to serve an emotive rather than cognitive function."
Why did you pick that
one? This connected up to, this was the second quote that I wanted to give connected to the Oliver Wendell Holmes thing. It doesn't quite link up to your last point, but
right,
because it kind of ties things off. We go
on to kind of separating the idea of order and law. Are we okay? Is there anything in between you want to mention?
Sorry?
The idea of separating order and law. Is that the next one, or anything in between you want to mention?
The separating order and law. I think we can go into that. Sure.
Okay, so and he says the real problem in our perception regarding this whole objective law issue is that from a very young age we are basically told law and order, they kind of fit together. There's a TV show even, and they're kind of one concept in our minds, right? Like to have law is to have order and vice versa, and you can't have order without law. And really that's how we get government and the government judiciary to play this role of order in society. Like if we didn't have government law, if the state didn't have a monopoly on law, the alternative is complete chaos. And I think that's how almost all people think.
Yes.
So yeah, he criticizes this concept and this is a big turning point in the text, where he kind of unmasks himself as the anarchist king that he is.
Let's go.
By saying, well, what if what if the free market supplied law? How about that? And maybe we should go through the monocysia thing. Actually, I think that might be a good idea.
Yeah. So I also want to say, I think I like the way, in terms of structure, he leads up to this, because he does reference, he makes this point several times, he speaks about state monopoly, he speaks, these kind of end of paragraph little mentions of like, if, what if we didn't have the state in control of these things, or what if they were left to market forces? Anyway, so monocysia is a country almost identical to the United States. However, for some reason, lost to history, I'm quoting now, the Monocysian founding fathers had included a provision in the Constitution that required all shoes manufactured or imported into Monocysia to be the same size. The particular size could be determined by Congress, but whatever size was selected represented the only size shoe permitted in the country. As you may imagine, in Monocysia, shoe size was a serious political issue, although there were a few radical fringe groups which argued for either extremely small or extremely large sizes. Monocysia was essentially a two-party system, with most of the electorate divided between the Liberal Democratic Party and the Conservative Party. The Liberal Democratic position on shoe size was that social justice demanded the legal size to be a large size, such as 9 or 10. They presented the egalitarian argument that everyone should have equal access to shoes, and that this could only be achieved by legislating a large shoe size. After all, people with small feet could still use shoes after they were too large, but people with large feet would be completely disenfranchised if the legal size was a small one. Interestingly, the Liberal Democratic Party contains a larger than average number of people who were tall. The Conservative Republican position on shoe size was that respect for family values and the traditional role of government required that the legal size be small size, such as 4 or 5. They presented the moralistic argument that society's obligation to the next generation and government's duty to protect the weak demanded that the legal size be set so that children could have adequate footwear. They contended that children needed reasonably well-fitting shoes while they were in their formative years and their feet were tender. I've lost myself. Later, when they were adults and their feet were fully developed, they would be able to cope with the rigors of barefoot life. Interestingly, the Conservative Republican Party contained a larger than average number of people who were short. This is the political environment in which, Monocysia exists.
So he then introduces this character he calls Socrates. Like the Greek.
Socrates. Come on.
Socrates. Well, I just, as I read it, I realized this is a pun on socks, like because of shoes.
Oh.
And then it messed up my brain. I was like, oh, socks, Socrates, sock.
Well, I'm glad you didn't say, oh, I've only ever read it. I've never heard it. That would be crazy. Anyway,
so this sock guy, Socrates, he makes up this character who comes up with this idea that what if we amend the Constitution to simply break up the monopoly on shoe size of the government, and you can make any shoe size you want. What if we just leave it up to the market, and everyone who wants to make a shoe company can do that, and they can make any size they want? And so, his father says to him, that's a very interesting idea, son, but it's simply not practical. There's always been only one size shoe in Monocysia, so that's just the way things have to be. People are used to living this way, and you can't fight City Hall. I'm afraid your idea is just too radical. So this guy, he's not happy with this, and he grows up and he goes to the liberal Democrats and presents this idea of free market shoes. And then they tell him, your idea is fine in theory, but it will never work in practice. If manufacturers could make whatever shoe size they wanted, consumers would be at the mercy of unscrupulous business people. each manufacturer would set up his or her own scale of sizes, and consumers would have no way of determining what their foot size truly was. In such a case, profit-hungry shoe salespeople could easily trick the unwary customer into buying the wrong size. Without the government setting the size, there would be no guarantee that any shoe was really the size it purported to be. We simply cannot abandon the public to the vicissitudes of an unregulated market in shoes. So he's like, okay, these left-wing guys are crazy. I'll pitch this to the conservatives, who then go, there's a little add-on by the liberals, saying the shoe market is unique. Adequate shoes are absolutely essential to public welfare. Therefore, the ordinary laws of supply and demand cannot be relied upon. And even if we could somehow get around the practical problems, your idea is simply not politically feasible, etc., etc. So he goes to the conservatives thinking, well, these guys probably should see my view, right? Because they want, if we can have all kinds of shoe sizes, then children can have their shoes and you can have your shoes and so on. And the conservatives say, look, Monocysia is the greatest, freest country on the face of the planet, and its respect for our traditional values is what has made it that way. Our constitution is based on these values, and it has served us well for the past 200 years. Who are you to question the wisdom of the founding fathers? If you don't like it in this country, why don't you just leave? So yeah, Socrates, Sockman.
Socrates and the liberal Democrats.
Okay. He finds that these people are all unreasonable, but he's not going to get anywhere. The conservatives. Yeah.
Yeah, the conservatives also say you'd be abandoning the rule of law, you'd have to amend the constitution, blah 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 blah. And then we also learn that the outcome of this is that they end up coming to like a size 7, right?
Yeah. So they average out.
They kind of, some kind of averaging out. There's a couple sizes above and below, and the shoes themselves are made in a way that they can kind of stretch to people's sizes. Yeah. So what is the whole... Is there anything you wanted to add on there? Sorry, I just kind of cut you off and jumped in there.
No, I like... This is unrelated, but I like how he ends the story by saying, after this experience, Socrates came to realize that there was no place for him in the political realm. As a result, he went off to college where he took up the study of philosophy. Eventually, he got a PhD, became a philosophy professor, and was never heard from again.
Yeah, very good.
No, but the point, of course, of this parable is that this is exactly how liberals, conservatives, and even moderates, anyone would react if you propose an idea so radical as the free market supplying legal services, or rather the free market supplying order, because we have to differentiate again between order and law, right? Hasnas says law simply supplies order in the current system,
yes,
but there are other ways we could supply order without government law. And, so of course, it's these kind of points you would hear. This is, and we even hear this with healthcare or things like that, right? We know the free market in every example that has ever been observed by humans. If you supply a good by the free market, it always gets cheaper, the quality gets better, there's higher diversity of things, and you're able to serve more consumers, increasing the wealth of the country and the quality of the service. But every time we talk about, a new thing that we could supply by the free market, it's always the same criticisms like, oh no, but this is an essential good, this is an exception, If we lift this up to the free market, there would be profit gouging, and this is just too important a thing to leave up to the market. Government has to supply this. This used to be, for example, the post office in many countries, which has now been largely privatized, of course, or even if the post office is still nationalized, we have other services like DHL, which people choose instead. Or even like public transportation, for example. I recently traveling in Asia, I used this kind of Uber-like service called Grab, but really it's Uber, right? So, and I think the reason why a service like Uber is so popular in places in the US, especially like New York and LA and shit, is because public transportation is just so dirty, so unsafe. The kind of creatures you meet there it's a really unpleasant experience. So, even within the government monopoly on public transportation, the free market actually somehow figured out a better way to serve this good, right? Okay, but,
for the people that can afford it,
Yeah.
But yeah.
Which obviously ignores the fact that all the money that we're forced to spend on public transportation without knowing it through taxation, right?
Yes, exactly. And then we still have to pay for access to it on top. Yeah, that's a good point for sure.
Okay, but anyway, so he now pitches this case of free market law to us. I'll hand over the stick to you.
Okay. We kind of now move into this argument of his, which is about, like you said, how a free market could work, and this idea of a free market. Just before we get into that, there's a quote that I want to read and talk a little bit about. He says, "As long as the public identifies order with law, it will believe that an orderly society is impossible without the law the state provides. And as long as the public believes this, it will continue to support the state, almost without regard to how progressive it may become. The public's identification of order with law makes it impossible for the public to ask for one without asking for the other. Since under our current political system, all law is supplied by the state, all such calls are interpreted as calls for a more active and powerful state." There's one thing I would like to add to this, to complicate this a little bit, is so I agree with the argument, but I think actually, what's interesting is the level of the public's identification with order, identification of order with law, varies from country to country. So obviously, I come from the UK and I live in Japan, and we can take the response to COVID as a really good example here for how order and law are actually quite separate things.
Great point.
And are treated separately. So in for the case of mask wearing, for example, in the UK there was an explicit mask wearing mandate, right? So the response to the COVID outbreak was to enforce order through legal ordinance, and it actually, funnily enough, involved, maybe not with mask wearing, but with freedom of assembly in public places, in order to curtail that. People were actually going through like the British Constitution, which almost never gets referenced, in order to find legal justification for it. But on the topic of mask wearing specifically, mask wearing was enforced. There was a fine if you were found in a public place without a mask, and that is the way that mask wearing is credited with being enforced. In Japan, on the other hand, throughout the whole period of COVID, there was not a single legal ordinance that could have you prosecuted for not wearing a mask outside. And in spite of that, the mask wearing rate in Japan consistently stayed higher than the one in the UK. It rose quicker than in the UK. It stayed on longer than in the UK, and it didn't respond to any like legal stimulus because there wasn't one there in the first place. So, I think it's important when reading this to recognize that there are other solutions. Solution is the wrong word because it's not like it can be imposed, but there are other environments in which order can be found, and it's not just through law. This guy is kind of suggesting. Feels very much like this is kind of American Western understanding, which, and obviously because this is the country that he's writing about.
I think Japan is probably the only place where this actually works, which makes it so attractive in many ways. That, public order is generally be understood as a kind of function of your manners in society, or even like company policy, whereas like government actually stepping in with like a legal justification for upholding the public order is quite rare. And maybe you see it like musicians who don't have a license in Tokyo, like street musicians, the police every now and then shows up and it's like, nah, you can't play here, and then they're like, okay, sorry. But other than that, usually public order is handled through other systems. Good point.
Yeah. So we then get into this conversation about how the free market would work, and I think there's a really, this came. I read it and got this huge moment of clarity. It was great. It was like a great just sentence here about the, in answer to the question, how can a free market provide the, quote, order generating and maintaining processes necessary for peaceful coexistence of human beings in society, and what would these legal services look like in a free market? And he gives this great honest answer, which is that if human beings had the wisdom and knowledge generating capacity to be able to describe how a free market would work, that would be the strongest possible argument for central planning. The essential point here is obviously the free market works because we don't know how it works. There's this kind of like, we don't have the capacity to make these millions of calculations to calculate costs, for example, and calculate distribution. And the free market actually solves those problems for us without us having to do anything. And yes. That just like hit me like a train reading it, and I was like, yeah, this is so true.
It
doesn't help us. It doesn't help us to kind of say that it's the right thing to do, but it is like a clear kind of answer to that question. Yeah.
So to make this a bit more graspable if you're not really in the know about this debate. So for instance, take the classic like Soviet Union car manufacturing problem, right? There's only so many cars that the government planned for, but then there's actually this much demand, and you got to balance that out against like the billion other things you could do with that labor. Should you maybe instead have made food or medicine or built houses or whatever? Just the problem of a central planning economy versus the free market, right? There's thousands of consumers and suppliers with different needs and preferences that the central planner couldn't possibly know. So it's impossible to calculate the optimal social production. And so let's say if we were at the outset right here, before we had a free market in cars, and we're still at this, cars are still a centrally planned good. People would probably also say the same criticisms as the people in Monocysia about shoes, right? That we can't permit cars are such an essential social good, and we're already struggling to provide the correct amount of cars. If we leave that up to profit gouging businesses, they would just exploit the consumer, etc., etc. And the point here of the free market argument is not to say, if only we had a free market in cars, we would actually get all these different companies, for example, Toyota and Volkswagen and Mercedes, and they would make diesel, and they would make this kind of car, and then maybe at some point some guy like Elon Musk would come up and he would make an electric car, and that would change the whole market. The point is that we can't know this until it happens, and that we can't describe how the free market system would actually solve this problem. The only thing we can know, and I use the word know very assuredly here and not speculate, is that any good supplied by the free market will be supplied cheaper, more efficient, and of higher quality than centrally planned goods. And that's always the case. You're never going to find an example where that's not a case. Maybe that's good homework if you want to spend a lot of time looking at like Boeing and finding out that Boeing is actually a government monopoly. But
yes, yeah.
Anyway, so yeah, I'm very glad you picked up this quote. I had the same one marked. And that being said, that's kind of a cheap answer, of course, and people want to be convinced. And so you have to hear some kind of substantive thing, even though that's technically the correct answer he just gave. So he'll give another answer of kind of speculating how the free market could look, even though that's kind of self-defeating to even ask that question, right? So the first point he mentioned is that actually free market law services are already all around us. On the one hand, common law, as we understand it, actually did arise from a kind of free market, throughout all the kind of European medieval times. A lot of our common law practices are not invented by some genius government planner, but actually are kind of cultural norms that simply have taken the shape of law, as well as other aspects such as, your homeowners association or like university rules. These are all systems beside government law where bodies have regulated themselves according to their own needs. And I think I've mentioned this on a different podcast. If you have a noise complaint, you don't actually sue the guy in a federal court. You probably just call the management company of your apartment complex and are like, hey, the guy is being loud. Can you tell him to shut the fuck up? And then if he doesn't do that, then they can still kick him out because he signed a contract where it said he can't do that. So
Yeah. So another thing that he gives a bunch of different examples of how communities, either pre-government or kind of like how different communities kind of managed to negotiate this as well. And it does come across as a bit kind of like, okay, we can give as many examples as we want about anything, but of course he is aware as well that like, he does need to give some kind of substantial evidence and argument.
I think the point about you're probably about to get to it, but the point about it being more the current system being very adversarial.
Yeah, that was the next point I wanted to go to.
Yeah, please take it away.
I thought this was a really, really great point. He says, our current system of adversarial presentation to a third-party decision maker is an outgrowth of early public choice considerations. I'm jumping into this paragraph a little bit late, but he talks about the reason for this this like arrangement is to do with like medieval kings, and he said the current state supplied legal system is adversarial in nature, pitting the plaintiff or prosecution against the defendant in a winner-take-all, loser-get-nothing contest. The reason for this arrangement has absolutely nothing to do with this procedure's effectiveness in settling disputes and everything to do with the medieval English king's desire to centralize power. For historical reasons well beyond the scope of this article, the Crown was able to extend its temporal power relative to the feudal lords, as well as raise significant revenue by commanding or enticing the parties to local disputes to bring their case before the king or other royal official for decision. So it's kind of like pitting competition for the benefit of the king. Our current system of adversarial presentation to a third-party decision maker is an outgrowth of these early public choice considerations, not its ability to successfully provide mutually satisfactory resolutions to interpersonal disputes. In fact, this system is a terrible one for peacefully resolving disputes, and would be extremely unlikely to have many adherents in a free market. So no judges, basically. You're in a situation where, you have your representative, maybe your partner has their representative, or there's some kind of thing that you both contract into, like you said earlier, the housing association, for example. And it's not about each party seeing themselves as someone who needs to emerge victorious and take everything from the other, but it's more like kind of a negotiation you would have with anyone. Like if I had a noisy neighbor, maybe the solution would be to call the management company. Maybe the solution would be to talk to them and say, okay, if you want to have a party, have your party on this day because I'm going to be out of the house this day of the week and stuff, and something like that. A compromise where everyone can be happy, or a compromise which doesn't involve the destruction of the other person.
Yeah, he mentions the problem is that in the current legal system, the loser gets nothing. So the incentive is that if you lose the case, that you have every reason to reopen the dispute, to take it to a higher court. And we often see this all the fucking time, right? We have this year-long legal case. This guy wins, then the other guy is completely fucked, like financially, as everything else. And so he takes it a step higher to a different court that then argues in his favor. Then the other guy takes it to the Supreme Court, and it's this system that is built on incentives of just lengthening the process, which really impoverishes the people who are actually having the dispute, and is obviously very beneficial for the lawyers and the courts because that's how they get paid. But in a more free market system, the where there's competition, obviously the pressure is always on the service provider to provide the service at the lowest cost possible and to the highest satisfaction of the consumer. So, maybe you wouldn't get like a court ruling where, I don't know, let's say the neighbor's dog shat on your lawn, and what you're looking for is that I don't know, he has to put the dog into some kind of training program, federally mandated training program on how to control your poops or something like that. Or maybe the dog isn't allowed outside anymore. Maybe the dog has to stay in the house now. But, and this could, we could have a legal process of, tens of thousands of dollars that takes months to resolve. Whereas in a free market system, the incentive structure of the legal service provider would be simply to mediate the conflict. So maybe instead of spending all this money on long debates in court, we would simply say, okay, the guy whose lawn gets shat on, you get $1,000, almost like an insurance, that maybe the other guy doesn't even have to pay that. Maybe it is literally like an insurance, right? And now we're all happy, right? Yeah. And the other guy said the dog won't do it anymore. Are we happy? And then they go, I guess we're happy, and we're done. So
yeah. And maybe there's a provision if it happens again, then there will be a direct fine to the person, or there will be some kind of actual penalty or something, so that there's a precedent, or like there's a statute that's agreed upon between only these two people. There's like it's like this. You're not going to be using this in the future to argue that Amber Heard shouldn't have shat on Johnny Depp's bed.
You're not going to dig up some statute from 1850 where the dog was put down when he looked at the master angrily or something.
Yeah.
So the dog gets to live and the other guy gets some money and we're all happy.
My question is like how this works in like, it's quite easy to imagine in like small claims like this, but what about when it comes to like you like murder someone? What happens in a situation like that? Like I couldn't quite make that jump in my mind, and I wasn't quite sure. Like I don't know if you have any thoughts on that.
Yeah, we'll find a good examination of that in Murray Rothbard's For a New Liberty. But so we're not talking about this text anymore at this point, but to give a kind of very general well, first the general answer of course would be that to imagine how the free market works would be to defeat the purpose of the point. But the nicer answer to kind of envision a possible future could be that it all has to do with the property rights of where you are to begin with. So we could assume that, for example, if you say you murder someone in a certain region that is controlled by even in contemporary society, we have this with like kind of BlackRock and Vanguard, right? Most assets are actually owned by a couple of companies. And so, you could say that if you murder someone in this region, then it would be in the interest of these companies to not allow you anymore on their premises. So that involves all the roads and all the stores and everywhere in let's say North America or even Europe. We could include Europe, perhaps. Maybe they have an alliance.
The United States and BlackRock.
Yeah. So, you'd simply be outcasted, kind of like in medieval times almost. And
right.
In this scenario, and maybe the person who got murdered got kind of like an insurance claim as well. They got a bunch of money. That would probably be more beneficial to the society than the current system where the guy who murdered someone now is put in prison, where he costs the taxpayer an insane amount of money, because literally prison is so fucking expensive. So you're actually kind of subsidizing this guy now. We're giving him free meals. Obviously he's not happy about that either, because he's in prison. Like, it's fucking horrible being in prison. So we're spending money making everyone unhappy, basically. And the guy who was murdered, he didn't even get anything. Instead, we could have used all this money we're using on this guy to send this guy to prison. We could have given that money to the victim, right?
Right.
So that is kind of an answer.
That's a great answer. That's really interesting to think about.
Yeah, the point Rothbard makes is that there would be no reason for concepts like revenge, or like making, like, it wouldn't really be a moral case. It would simply, how can we make these parties happy, and resolve this dispute as painless as possible. And so this, I think, from a kind of Christian perspective, I guess from a Christian perspective it's not that problematic, but from like a justice kind of perspective, a lot of people would maybe feel like this would be outrageous that we can't punish this guy more directly. And if of course many people hold that view, then companies would adopt to serve that demand as well, right? So if we say that people actually really want these people to like serve a duty to society, we can't enslave them in libertarianism, but maybe we want them to contribute. Then maybe if they use any service because usually you would have everything digitalized anyway with payments and shit. maybe you would put a tax on those kind of people almost. Like if you stabbed someone, every time you buy something in a shop owned by all the major companies, you now pay 100% tax that goes to the victim. Like if you buy an apple, that's $2 that goes to the victim, and so on, right?
Or it could be your wage, for example, as well.
Yeah.
But the essential point that you made there as well, I think is important to underline, is that if there is this kind of natural occurrence of people who, for example, do believe that there should be punishment for committing a murder, which I think is not controversial at all. It would therefore become a demand within this marketplace. So, in order to and for those legal companies and insurance companies, in order to appeal to this mass of people who have this certain belief, they would mold their services in order to reflect that, and that would then go to kind of reflect it would be like a more natural reflection of the actual area, rather than someone kind of like, because it would be the opposite would be true. It wouldn't be a free market. It wouldn't be like a perfectly free market outcome, or like at least in theory, if there were a bunch of people living in this place who wanted punishment but weren't getting it through the companies that existed, right? That would be seen as a market left untapped, and if that were a kind of enforced thing that you couldn't punish someone, that would be like a manifestation of the state. If that was like enforced by like something that had a monopoly on violence.
Yeah, and I also consider what is possible with technology today and what is kind of being done or kind of sinisterly in China, for example, with all the face recognition stuff. We could also simply exclude this person from all kind of services like insurance and like police protection. So basically, if you have like stores that scan your ID and shit, then we could advertise this person as he stabbed someone, okay, and he has 10 years left of like warning signs and not being under protection by this like police company, say. So basically, this is kind of a Heinlein scenario where this guy is like a known criminal now, and if he walks into the wrong bar and just disappears, no one's gonna ask questions.
Yeah.
Because he's not under protection anymore.
Yeah. Awesome. So I think we can pretty much wrap it up here. That's That's more or less where the argument finishes. There are no fixed answers about how this would really manifest in a perfect free market situation, but we can imagine why it could exist, and we can definitely levy some very, very strong criticisms as to why the state shouldn't have the monopoly on this. To offer my thoughts, I've kind of peppered this throughout, but I thought this was a very pithy and well-structured essay. I thought it gave a really, really good balance between like real-world legal cases and examples. It's written with quite a good, appropriate degree of humor, and it develops the argumentation really cleanly and really neatly. It felt like it was something written in the last 30 years and not something written 200 years ago, which is a lot of the stuff we've been reading recently.
Yeah, and he's always appropriately ahead of the reader.
I'm keen to read more of this guy. Yes, yeah. I've seen this guy has a couple books. I would be quite keen to check one of them out in the future.
Righty-ho. Well, if you have any questions, leave them in the comments, and we will probably revisit this topic at some point when we turn to Murray Rothbard in the somewhat foreseeable future.
Hell yeah, baby. All right, thanks for listening, everyone. Bye-bye.
Bye-bye.